You're saying denied because of the EOB.
Right, and I'm going to.
And I just told you, no, I'm not going to accept an EOB with a code as a formal denial. So that dog don't hunt. What's the next dog you're going to put up?
That is the dog that we're relying upon, Your Honor.
Okay, then I'm going with his date of denial that I think he's generously offering to use as a formal denial, because it's an email that, and I agree with you, counsel. I've received them formal denials. We're not covering that claim, Oakley. And it's a letter with a name on it, and appearances for Preferred Medical versus Progressive Marathon.
Your Honor, Freddie Sackler appearing on behalf of Preferred Medical Appointment.
Good afternoon, Your Honor. Nicholas Ackerman appearing on behalf of Progressive.
Last name?
Ackerman appearing on behalf of Progressive.
Thank you.
AUKERMAN. Do you also like my P number? 85192. Of course.
All right, gentlemen, if I remember right, we tried this a couple weeks ago and I just couldn't hear half of what was coming out of one of your mouths.
It was my mouth, Judge.
Yeah. So now it's a much better connection, counsel. Sit, guys, be comfortable. You don't have to jump up to talk to me. It's okay if you do, but you don't have to.
Appreciate it.
All right, so let's hit some high points. Plaintiff? No, actually, it's your motion. You filed the motion.
It's my motion. I had the opportunity to speak last time.
Yeah,
it was
go
his
ahead.
turn. Would you like him to just pick
No,
up?
yeah, that's all right. Yeah, go ahead, Mr. Sackler.
Okay, so Judge, ultimately, the defendant's position is that some of our claims should be denied because they're outside of the statute of limitations.
Right.
Okay. Where we left off last time is the first thing I did, Judge, is I'm looking at my notes on my phone, but
Sure.
3/16/22 to 5/1/23. Those are our dates of service. And I walked you through Exhibit 1, which is, I'll show it to you. It's the dates of service. Okay? And these are the dates of service which we're coming after the defendant for in this case. The initial invoice was 3/16/22, and everything is later. So the question for this court is, do we get to go back to 3/16/22? The case law is very clear in MCL 500-3145, says until there is a final denial, if insurer formally denies a claim, the statute never stops. Okay?
Right, I'm with you so far.
So we will take you, Judge, to, and there's also case law, and I think it's East First Health, it's quoted in my thing, that an EOB is not a denial. It's not considered a formal denial. Okay? And the goal of the case law is that the courts want us to work with the defendants and the defendants to work with us and not file litigation that's unnecessary and have a clear answer of what everyone needs to do moving forward to not waste time and headaches. So what I'm going to, Exhibit 4, I'm going to have the court go to Exhibit 4, and that's kind of where we left off last time.
I'm flipping. I'm with you.
Now, this is not a case, Judge, and you can see from the defendant's exhibits too, but this isn't a case where we're not getting paid at all. This is a case where the defendants randomly decide what they're going to pay us. We have set fees that many carriers pay us. We do only transportation for brain injury individuals who have been getting treatment for quite a long period of time. We stay out of the whole, is this person covered or not covered,
Right.
or is this injury covered? So we've been paid, but the problem is we're getting paid 30 or 40% or 20% or randomly whatever number they decide to pay us. And that's why we sue.
Right.
In this particular situation, we started discussing that with Progressive, the defendant. You can look at the second from the last page of Exhibit 4, the bottom email dated February 3rd of 23 at 1:57.
Yep.
And you can see that we say for two, and now this is an email from Progressive coming back to us and says, for 2/22/22 and 2/28/22, billing appears that payment was stopped because it was mailed to the wrong address. So in this chain of emails, we're talking about the invoices in February of 23. We're talking about these invoices in February of 22. See that?
Yeah.
Okay. Moving forward, if you look at the emails going up, you get to an email at the top of the page on February 6th, where we say, good morning, were you able to discuss increasing the loading miles? Because again, we're not getting paid what we're supposed to be getting paid. Finally, if you go to the page before of Exhibit 4, which would be the first page of the exhibit,
Right.
and you go to the middle email on February 6th, we get an answer on February 6th from Progressive that says, I have discussed this and I am not going to be able to increase the rate. There was talk about negotiating the rate for a lower, and they ultimately tell us in an email no. Now, again, I don't know if that's formal because the case law on what is formal, and it doesn't really matter, but our position but the case law on what is formal is that basically, Judge, I mean, you've seen a denial letter from an insurance company. I think the quote is explicit, unequivocal, impress upon the insured the need to pursue further relief in the court. When we get a formal denial letter, you've seen them. They come in, here's our policy, the reason they were denied.
Right.
Okay. So, but we don't even need to get into that because the first time they actually said anything to us that they weren't going to pay the fee that we were charging for the February of 22 invoices was on February 6th of 2023, which means we would have a year from February 6th of 23 to collect on any invoice from February of 22. And we filed our lawsuit on November 28th of 23. So we filed well within that year. And that email was February 6th, where they denied us. And the invoices we're collecting from are from the following month, March, moving forward. So we're well within our 1 year statute of limitations because it was pulled until they formally deny our claim. And there's nothing where they formally deny it prior to February 6th of 23.
Okay.
Yeah, 23.
Okay. Mr. Huckerman, back at you.
Thank you, Mr. Honor. With respect to brother counsel's articulation as to the facts of this case, it's not simply true that defendant randomly or sporadically made payment, made partial payment, or just simply outright denied payment. That's not the case. In terms of there's a few things I have to break down. So, according to our respective claim notes, which are the conversations pertaining to the insurer to the insurer or the insurer to the attorney in preparation of litigations, internal conversations, if you will, when the claim notes are always redacted and provided to opposing counsel along with the privilege log and claim file, right? They have that information. It was our understanding originally as of April 26, 2022, a conversation in which the actual outstanding portion of the payment that was made was discussed because there was an agreement as to what was going to be paid pursuant to the services that are not at issue. We're not discussing the type of services at issue. We're not discussing the reason for the services at issue. We're just simply trying to articulate as to why defendant believes it paid what it did and why it did versus opposing counsel saying they simply just want more money versus what they've received thus far. So our understanding according to the claim notes that brother counsel has been in possession of since April 26, 2022. Good morning. This is the insurer, the client allegedly reaching out to a member of the preferred medical transportation facility. I'm in receipt of your balance bill for October 1910 or October 19th through 31st of 2021. However, our medical representative Marley called on October 18, 2021 and spoke with Justin where they negotiated a $35 pickup and drop off as well as $3 per mile. That is what we paid. Please file accordingly. Please update your file. And that email also went out according to our claim notes again on May 2nd of 2022. Now it's our understanding that we've had this conversation a while ago, well before the November filing date of 2023 for opposing counsel to even argue that some outstanding bill is allegedly at issue before this respective court. Now, brother counsel also brought up without necessarily providing any kind of examples as to what actually is a specific formality, because unfortunately the Court of Appeals did not actually really give us, But based on case law and precedent, multiple PIP files filed before every court every single day, because there's so many auto accidents, unfortunately, we kind of understand what those formalities look like. And the case I believe Brother Counsel is really trying to discuss is Encompass Healthcare PLC versus Citizens. That's 344 Mich. App 248, came out in 2022. Really, essentially, Encompass held that while a formal denial not be in writing, it obviously must be sufficiently direct. So that way, medical providers are not necessarily guessing, why are we not getting paid? Well, every single explanation of benefit sheet that is presented to the court, filed with this court, attached to defendant's respective partial MSD, the explanation for every single one of those gives an actual example as to why payment was not made. And the very first time they ever received an explanation of benefits, the document date from Progressive is April 24, 2022. And on that second page, under explanation code, it says quite clearly, this payment has been negotiated and agreed upon by the provider representative. There's no ambiguity as to why Progressive made the payment that it did.
Let me stop you there though, because wasn't there a response from them that said, wait a minute, we didn't negotiate anything?
That's
In response to that email, there was a response back that said, wait a minute, we haven't negotiated any rates.
That's their assertion that they didn't have this conversation, but it's our understanding that we did have a conversation back in April of 2022 and May 2nd of 2022, where we came up with that negotiated rate in the first place, which is why payment was made. Again, the date of service go back to March of 2022.
Okay, so you say you've got email records of a back and forth with an agreement of a new rate going forward.
I don't have the email per se. I have the claim note drafted by the actual client that encapsulates that conversation, is what I'm saying. Which the claim note itself is always presented to opposing counsel. They get the claim file, claim notes.
Okay, but what I've got to find is a meeting of the minds. Otherwise, it's not really a negotiated rate. Would you agree with me?
Sure, but
how can I find a meeting of the mind from some internal memo that's very self-serving?
Well, okay, so hypothetically speaking, say if we're going to push aside our original conversation 30 days after the first payment, because we paid consistently, if a bill came out that month, we paid 30 days later, right? Payment has always been made consistently. Right. They've always had and received every single explanation of benefits pertaining to each respective data service.
Yeah, but at some point they said your EOB that refers to such and such code doesn't tell us anything. Quit using that code.
But they waited so long in the first place that there's no reasonable diligence that they took to argue the 1 year back rule or because the 1 year back rule essentially was amended following the No Fault Amendment Act, right? And we're essentially arguing, well, they really shouldn't necessarily be saved from the 1 year back rule or have any kind of tolling, if you will, to allow them to have this ongoing argument that they can actually still make a claim for the outstanding expenses. Because under the MCO 531.43.3, which is a newly amended portion of the No Fault Act, reasonable diligence is a precondition to invoking the tolling set forth in the preceding sentence. They waited 19 months with filing the lawsuit to even go after these respective allegedly outstanding claims, a portion of the claims that we've been paying for, even though they've had the explanation of benefits that are clear and unambiguous. Now, if the EOB simply said something along the lines of pending investigation because of, that would make a little bit more sense as to whether or not the medical provider can ensure that payment was being made. Even Brother Counsel's own respective response to defendant's partial MSD quite simply states, like, we were hoping that since payment was being made, we were essentially assuming that payment will be further made to avoid litigation or something along those lines. But again, if they wanted to have that conversation, they could have done so well before November of 2023 when they even filed this lawsuit in the first place. Because again, the first EOB that came out was on April 24th, 2022, and that pertains to a March 1st, 2022 data source. So if we want to put aside, for example, our claim note that suggests that there was a contract agreement versus their email out in April of 2023, so a year after our EOB even came out in the first place, well, they still have the EOB regardless to say, hey, payment was only made up into X amount of dollars. Well, where's the rest of the money? They didn't reach out until the lawsuit was actually filed or until that email came out a year later in April of 2023. Then I guess that's where Brother Counsel also did not give me an example, Your Honor, as to what specifically or explicitly must be produced as a formal writing. And Compass doesn't say that there must be a formal letter denying every single payment as to why. That will be an even more voluminous amount of paper on top of what the EOB clearly states. Payment was made according to a negotiated rate or other explanations, non-covered service. Again, there's nothing in here that's ambiguous that would suggest that the medical providing facility could, I guess, in a sense, rely upon to their detriment that, okay, maybe they're just figuring it out. there's no figuring out information in the OB that would even give them the opportunity because they know what they're going to get paid for. If they had an issue with us alleging that there was a negotiated rate, which we say there is according to our claim note, then that conversation should have happened a lot sooner, which is why we're trying to argue in our REFOR section for relief, pursuant to 531.45.2, the claimant may not recover benefits for any portion of the loss incurred more than 1 year before the date in which the action was commenced. So if that's the case, then they're prohibited from recovering benefits incurred prior to November 16, 2022. And we're pushing for that date because they lack the reasonable diligence of actually contesting what was actually due in a reasonable manner. Again, they waited 19 months. Now, if the court wants to agree with opposing counsel and that they at least got to us at some point in time, but the 1 year back rule still applies, well, then they're going to essentially be barred from benefits up until about October 15, 2022. So we're arguing it's going to be the 1 year back rule one way or the other. Are we applying the reasonable diligence standard that came post-reform, or are we just going to adhere to the pre-reform of the 1 year back rule as to what we're going to bar in the first place? At least that's what the defendant is contesting.
Go ahead.
Okay. Counsel has a kid for cheating. Judge, first, their claim notes mean nothing. They're hearsay. They're self-certain. Second, the letter that we wrote saying, "Hey, you decided on your EOB, which isn't the law is clear that that's not a denial." But I'm reaching out to you today regarding the explanation of benefits, where we receiving explanation of benefits we are receiving from this file from Progressive that is giving an explanation code of 314, which states the payment has been negotiated and agreed upon by the provider and the provider's representatives. Please note, we have not negotiated a rate or any rate with you, and if you make a statement on the EOB, for you to make that statement on the EOBs.
When was that dated, counsel?
Well, that's the most interesting part. That's dated April 6th of 23. Now, do you know why that's dated April 6th of 23? Because I'm going to show you what's attached to counsel's motion as his Exhibit B. And Judge, counsel says that they just paid us on time all the time. We should always know what's going on. But this is the explanation of benefits for the dates of service of April 1 of 22 to April 8th of 22. And it was sent to us on February 9th of 23.
9 or 10 months later.
Yeah, it was sent to us the whole year. So we actually started our lawsuit. We track these things. We know when you deny something. You wrote us your email on February 6th telling us you're not paying us anymore. We track our invoices and we file our lawsuits timely. We're allowed to go a year back from the denial if you deny us. So accepting that there could be, even though we believe the case law is very clear that even that email is not a formal denial. It's not signed by anyone. I mean, a formal denial is a signed document denying the claim. There's a case law very specific for formal denials. But accepting that email would be, we go from the email until a year later. We filed our lawsuit well within that year. So we filed it in November, April to November. So we get to go back from 2022 because that email where they denied us in 2023 was the invoices in 22. We were negotiating with them a whole year trying to get them to do what we needed to do, telling them, hey, you still have to pay this one. Hey, what is going on with our rates on this? Finally, they write us an email denying. Then they issue the payment for February 22 and 23. This is their date of service. So this isn't so, and I can approach and show the court what wants to see. But this isn't so. I mean, listen, I don't play into a world of everyone doing a million cases. I litigate these cases. You're going to see me get paid for the day of trial. I tried this case. This isn't one of those situations, Judge. They didn't pay us. We sued timely. We could actually, if we really wanted to, go back. We could have waited another couple months before we filed the lawsuit. We had until February of 24. We filed in November of 20. That's it.
Anything else?
If I may, Your Honor.
Sure.
Again, Brother counsel doesn't give me case name, case law, any type of statute whatsoever. He's just simply asserting his understanding of the case interpretation one way or the other. But at the same time, again, the original explanation of benefit that the document date states April 24th, 2022 in the first place. We've had this conversation. They knew what the conversation was and they did nothing then up until 2023. And then they waited till November of 2023 to even file the lawsuit in the first place. So what we're arguing again is whether or not there's reasonable diligence or not, they waited 19 months to file the lawsuit to even contest these respective claims in terms of how much the defendant has paid, partially versus what they're demanding the remainder amount to get the quote unquote full amount in the first place. So that's why we're asking if the court believes that there is reasonable diligence into the first place. Well, okay, so then the 1 year statute in the first place will then hold the date from the specific claim up until November 16, 2022, instead of that October date of 2022.
So here,
And
all right, and this is not my realm, guys. I never see these cases, okay? I know some district courts see these cases all the time. We never see them. So I'm struggling with this just because it's all, rarely do I see them. So the way I understand it is the first thing we have, before we start talking about a clock ticking, the first thing we have to have is a denial.
Mhm.
We agree on that?
Mhm.
All right. You're willing to say, just for sake of argument, Judge, let's just take that email and that's our denial. Even though you say it wasn't signed, so on and so forth. But you're willing to say, okay, Judge, let's just say that's our denial. Does that summarize your argument?
That summarize.
Okay. If that's not the denial, then what was the denial? Because I got to find a denial before I start counting 12 months off.
sure.
What was the denial if that wasn't it?
So the EOB in of itself is no, because it puts them on notice as to why payment was made in the first place. There
No,
doesn't have to be a respective formal writing.
Okay, you do talk fast. Slow down. Answer my question. My question is, what is the formal denial you want me to use to count? What's the denial?
Your Honor, that would be the explanation of benefits that lays out specifically and without ambiguity as to why payment was made in the first place.
So
That
the
puts them on
EOB
notice.
that they referenced in April 6/23 saying, quit using that code, we need to negotiate anything. You're saying those constant EOBs were a denial every time that EOB was mentioned.
Correct, because there's,
I'm not buying that
okay.
at all, especially when they've disputed it as of April 6, 2023.
Well,
So I'm not giving you that as a constant denial every time an EOB comes out. So where are you going to hang your hat next for denial?
the reason why, if I may just clarify one more time as to the EOBs, Your Honor, if I may. So plaintiff's claims were denied as they were received typically within a 1 month period of 30 days that the claim came in, the date of service that the payment went out.
But once again, you're saying
Right.
denied because of the EOB.
Right, and I'm going to.
And I just told you,
Okay.
no, I'm not going to accept an EOB with a code as a formal denial. So that dog don't hunt. What's the next dog you're going to put up?
That is the dog that we're relying upon, Your Honor.
Okay, then I'm going with his date of denial that I think he's generously offering to use as a formal denial because it's an email that, and I agree with you, counsel. I've received them formal denials. We're not covering that claim, Oakley. And it's a letter with a name on it and everything else. So if that's the date, then how's that affect your time frame of claims?
Because essentially, it protects them from even having to have a conversation with respect to tolling or even the 1 year backward, because they're essentially saying that the claims before the respective the court is in fact proper, and therefore they can claim those outstanding. That's why we're relying upon on MCO with regards to 3145-3 or 3145-2, whether it's post or pre-reform. The claims that we're arguing can or cannot be then sought after in terms of the partial remainders that are allegedly outdue, Your Honor.
Okay, and once again, I'll put it on me. I don't hear as fast as you talk. So I'm using his date with that email, and you're saying now we have to look at whether or not they filed suit timely, whether or not they used due diligence. Correct? Now, the way I understand plaintiff's argument is, during all that time period, we're going back and forth between the parties. We're going back and forth. So that's why there should be a tolling. So once again, correct me if I'm wrong. I think what you're saying is there was a delay, but we used due diligence because we were still talking.
They didn't even actually issue an explanation of benefits for the 2022 dates. That's what I'm telling you. They didn't actually issue an explanation of benefits for the April 1st, 22 service dates. The explanation of benefits was issued on February 9th, 23. So they didn't actually pay us for the April 22 dates.
Until February of 23.
Yeah, for shortages.
Right. Well, they paid you, but they didn't pay you everything you wanted.
Exactly. They didn't pay us what we know.
Right. February 23. And when was suit filed?
November of 23.
Right.
So 6 months later.
Okay.
Whatever that is.
Okay. All right. Anything else, gentlemen?
Not this time, Your Honor.
No.
All right.
That brief does outline a lot of.
All right. Motion's denied. Anything else?
I'll have that order filed with this court today, Your Honor. I'll have this order filed with the court today.
Thank you.
Thank you, Your Honor.
All right, guys.
Nice seeing you in person and Judge, that morning, I know you don't care.
No apologies.
But yeah, it was internet, my house went down. And I was on watching TV and I had court person.
Look, if it was up to me, there would be no Zoom.
I love you. So
Yeah,
just saying sorry. Give me one
You're
more
not the
shot.
only one.
Give me one more shot.
So fellas, let me throw this out. This isn't a big claim. What is it, $6,600, something like that? If it would help you, Judge Green and I have been kind of informally trying to facilitate each other's civil cases. So, and she loves Zoom too. So if you guys think it'll help you, if you two agree, then I'll just put you in contact with Judge Green. She'll schedule something on Zoom and she'll just kind of walk you through and see if she can help you guys reach a settlement, if you think that's helpful.
We're always, the facilitation by a judge is the best way to always have it, Judge. So
Well, and it doesn't cost anybody anything.
Exactly.
You know, and I can guarantee we'll schedule her quicker. You could get something scheduled downtown. So if you think it'll help, just contact us.
I do. I just need a consent from my client, but that's something
No, that's,
I can certainly discuss.
just reach out.
Yeah.
Yeah. If nothing else, just you guys send an email to Sandy and say, we'd like to have an informal facilitation with Judge Green, and I'll take it from there.
take your.
All right. Have a good day, guys.
Thank you. Good one. Safe drives.
Drive safe, fellas.
All right, so I got this meeting with our.
Isn't it? Yeah. Thank you.
I mean, many times, no problems, it was my first time here, it's great.
Yeah.
It's not, I mean, it's nice that you guys have done such a beautiful place. It's not fair that, everything we do.
No, and that's my major problem is, you know, we built this extra big space because we were really busting out of the seams in the old building. And now, A, a bunch of stuff is on that damn thing, and B, our case numbers aren't there.
Yeah, all of your.
So we've got this nice new facility and we don't really need it right now.
It's simply.
Someday I hope we get back.